Okay, good evening, everybody. I think we'll start. Okay, today we are going to discuss criminal procedure code. I hope with you are ready with this criminal procedure code statute because most of our time we are going to rely on this statute. Before I begin the class, I just want to make some disclaimers. This is a pro bono class, and I'm just a junior lawyer, and this class does not aim to cover all areas of law and information, of course, with the development and also evolve of the law, case law, etc. So the accuracy of this information cannot be forever warranty or guarantee, and I do not have any conflict of interest, and I will appreciate any of your constructive feedback in my class. Okay. Okay. Talking about this criminal procedure code, this is a very practical question, ladies and gentlemen. I hope you understand that you are not studying substantive law, but rather you are studying something procedural. That's why it is named as criminal procedure code. So I would advise you all how you read this paper, how you are going to aim to pass for this paper would be actually you should not read too much of your textbook. Rather, you must spend a lot of your time to digest what this CPC is all about. Okay? You understand so far? So the important statutes that you'll use it a lot for all your CLP paper would be your primary laws in Malaysia. That will be our federal constitution. Apart from that, you're going to use CPC very, very often. You are not going to just know about the general idea about this CPC itself, but rather you are required to know the specific section or proviso of the law. Very important, ladies and gentlemen. And also, you are expected to know CJA 1964 that governs your superior court's operation and also authorities, as well as your SCA, Subordinate Court Acts 1948. Okay. And other acts, for example, you're going to see DDA, FIPA, SOSMA, Kidnapping Act, inside this criminal subject, but these are not so important. And rather, I would say this law itself, DDA, SOSMA, Kidnapping Act, all these are quite difficult if you are not really in practice. Okay, because I realized that during my student time, I do not have time to read so much. I I think that you are going to share the same position that I had before. Okay, but to secure a pass, you must master CPC, CJA, and SCA. Okay, this is the bare minimum. Okay, so this is all I've talked about lah, the FIPA and all that. Okay, so before you begin with your learning or even how to answer the question, you must understand that Malaysia court system is an adversarial system. It's not inquisitory. That means to say we have two lawan party, dua party yang berlawanan. The first thing is, of course, the prosecution side representing the state. Okay, and we have the accused, isn't it? Which is usually represented by private lawyers. So we call it as defense. And the third position, you have a neutral judge to determine the matters. So before you answer any question, you must read the questions carefully and know who you are in that particular question. If you are for the prosecution, you are not required to write down anything that is against you, but rather you should position your submission or your conclusion in favor of the prosecution that you are representing in that particular question. Okay, vice versa apply to defense. If you are for the accused, you must write your answer based on the position of you, like a practicing lawyer defending the accused. As simple as that. Okay. For you to understand this better, I think you need to know the criminal procedure flow of Malaysia. Okay. Usually, usually everything, or I would say almost everything, a court matter will start with a first information report. That is, in layman term, we call it as police report. That means to say somebody lodged a police report in Balai Police, for example, Batu Pahat, and then the police got to know a specific crimes have been committed, and then they have undergone some investigation. So it depends on the type of offense. They can actually arrest the accused. Okay, so this is how it happens. After arrest, for example, within 24 hours, the so-called accused person must be brought to see magistrate for a remand proceeding. Okay, during that remand proceeding, it is the absolute discretion of the magistrate to determine whether he or she grant the remand for the accused in order for the police to complete the investigation. Because somehow or rather, some crimes committed is very complicated. Take, for example, murder or some huge drug case. There are some intelligence involved. And then the police scared that the accused may abscond or run away to other country. So remand proceeding is just for this purpose. All right. And after that period of time, should the investigation paper completed, they will give it to the public prosecution. I mean, public prosecutor. The usually DPP is the one that handle it lah. The Attorney General Chamber, AG Chamber. So AG Chamber will determine whether they are going to bring the accused to face charge in Mahkamah or not. Okay. So far you can follow. If the investigation is showing that the accused got something lah, I mean to say highly suspicious to commit a crime, then the accused will face charge in Mahkamah. Usually, magistrate court is the one that read the charge to the accused. All right. So during that time, if you look at your CPC, you have your provision already. So what is the summary trial, or if the charge carry death penalty, okay, the case will be transferred to High Court for subsequent hearing and all that. So these are the basic principles of the process of trial. Okay, can understand? If you're not happy with the decision of, for example, a judgment or sentence or order that imposed by a judge, in Malaysia, we have two-tier system of appeal. That means from lower court, you can go to high court. And then from high court, you can go one more level to court of appeal. All right. That is for lower court case. And in fact, most of the case that exclude death penalty will be the court of first instance will be determined in session court or magistrate court. Okay. Only some so-called high profile case, like for example, our ex-prime minister, Datuk Sri Muhammad Najib case, it is straight away going to high court. All right. Like Datuk Sri Anwar Ibrahim's case also started in high court as the court of first instance. Okay. Other than that, everything is lower court. Can get me, eh? So if the case start from high court, if the accused or the prosecution is not happy with the decision made, they have two level against two tiers of appeal. They can go for court of appeal and end at federal court. Okay. And other than that, we have a special court as well for children. Okay. This is applicable for those who is being tried alone and committed crime when they are minor, less than 18 years old. Okay. So this is the court system in Malaysia. So lower court, we have a session court, magistrate court, court for children, and also special coroner's court. Special coroner's court, strictly speaking, is not adversarial system, but rather it is inquisitory system whereby a session court judge is being appointed to inquire on a cause of death of a person. The popular one usually, the whole proceeding we call inquest proceeding is for those who die in prison or in custody, the authority. Okay. And then we have High Court in Malaya and High Court in Sabah, Sarawak. And then subsequently, you have your Court of Appeal in Putrajaya and Federal Court also in Putrajaya. Special Court is only for the rulers. That means to say Sultan, Yang di-Pertuan Negeri, or Yang di-Pertuan Agong. All other ordinary court has no power to try them. Only special court can try them. But this is the list that you should have concern, because I don't think in your question some this unpopular question involving this area will come up. Okay. So today our topic shall cover the jurisdiction of the court, as well as the next topic we are going to discuss is about arrest. First of all, I would like to bring your attention to magistrate courts. So magistrate court, the criminal jurisdiction, I'm afraid you have to memorize the section very well. Okay, section 85 of your Subordinate Court Act 1948 provides that magistrate court can hear all criminal offences that is subjected to fine and imprisonment not more than 10 years or fine. Okay, please remember that this is where the trial can be heard in magistrate court. Okay, so what about sentencing jurisdiction? That means to say apa hukuman yang boleh dijatuhkan oleh mahkamah magistrate. Okay, even though mahkamah magistrate can hear the case that carry imprisonment more than 10 years and fine, listen carefully, but it doesn't mean that the sentence or the hukuman can exceed 5 years. And also fine also cannot, that means denda lah, ayah, wang, okay, cannot more than 10,000 or 12 times of whipping. Please memorize it. You have no choice. You have to memorize this section 87 sub rule 1 SCA. Okay, very important. Okay, because if you want to appeal, sometimes it's based on the legality of the sentence, So if let's say the mahkamah give 6 years, which is out of its jurisdiction, the whole sentence itself is illegal and it can go up all the way to High Court and Court of Appeal. Okay, I hope you understand what I'm saying. Okay, the first popular topic they like to ask you. Okay, even though just now we have a look, isn't it? Section 87 sub rule 1 said that the sentence imposed by magistrate court should not exceed 5-year imprisonment, or the fine, the denda, cannot exceed 10,000 or both lah, okay, or 12 times whipping. The question now is, can magistrate actually did sentence more than what is required by the law or not? Okay, so you must look at the jurisdiction. Okay, if you must go back to the doctrine of generalia specialibus non derogent. Okay, if let's say you have an act, that is the popular one is DDA lah, because Malaysia drug case really a lot. If you have opportunity to go to magistrate court all day long, you hear DDA here and there, section 12.2, section 15.1, something like that. Section 39A. Everything is about drugs, in Malaysia. So DDA itself is a specific statute for drug offences. And in which some of these specific statute did provide jurisdiction for the court to try and also to give sentences. I hope you can follow me. CPC, CJA, all that is just as a general, okay, general statute that provide general jurisdiction. But if let's say the accused is being brought to the mahkamah for a specific offense, this is, for example, the drug offense, okay, the right statute or the right section that you must rely on will be your section 41 DDA. If this is a drug case relating to DDA, I mean, yeah, this is drug trafficking, for example. Okay, in which the session court and magistrate court can actually cause imprisonment or memberi hukuman, okay, imprisonment more than 5 years. Okay, can follow me so far? All right. Okay, you see, I want to give you an example of section 12(2). Okay, section 12(2), which is related to the possession of drug. Okay, that is not the quantity is very little lah, 1-2 gram like that lah. Okay, so the accused will be charged under section 12(2) DDA, and the punishment will go like that in section 12 subrule 3, which say that if the accused is liable on conviction, that means is found guilty, the fine can go up to 100,000 ringgit or to imprisonment for a term not more than 5 years or both. Okay, so just now we have studied section 87 subrule 1. It said that the magistrate cannot impose fine more than 10,000 ringgit. But when we have this section 12(3) coming in for drug case, it is legal. Okay, that means to say, in your very simple understanding, if a specific statute provide jurisdiction for magistrate to do so, then the sentence is legal. Okay, so far any question? I need to know. Because if not, I think later on you got confused. Okay. Okay. Another exception that you would like to look at, even though it is a general penal code. We take example, theft, mencuri. This guy, for example, had been repeated offender, habitually steal from Kedai Runcit, 7-Eleven, Family Mart, got so much conviction. That means released after 2-3 years, then got caught again, something like that. So this probably is his 5th time of conviction. So sections 87 subrule 2 actually provides for the magistrate with their previous convictions to be punished more than the 5 years and also 10,000 fine. Okay, you get me? But somehow or rather, the magistrate, if they impose such excessive punishment, more than what is provided under 5 years and 10 years, must give reason, must record down in his judgment what is his reason to punish more for this particular case. That is, of course, needless to say, this is a repeat offender. The public interest element overrides the so-called the law itself. Okay, so usually public interest is very important thing in criminal justice. Okay, so next we look at session court. Session court, you have to memorize section 63 Subordinate Court Act 1948. That is quite simple because it has no monetary jurisdiction, just like your civil court. You need to memorize less than 1 million, etc. This one no need. So every criminal cases except the one that is punishable to death penalty. That is, of course, Section 302, Section 39B DDA, and some of your SOSMA, okay, FIPA. These are specific and the one that carry death penalty cannot be tried in session court. Okay, they must go to high court. Other than that, regardless this is a multi-billion case, the sentence can go to natural life, for example, until you die lah. I mean, the natural life, all this can go to session court. Okay, and Section 64 SCA said that session court can actually pass any sentence except death penalty. But somehow or other, you must remember they can fine a person 1 million, 2 million, no limitation with the fine itself. But in regards to whipping, rotan, the maximum sentence for rotan in Malaysia is only 24 strokes for adults, okay, per case, per trial, okay, and also 10 strokes, I mean school caning type for children. You can see in your section 288 of 288 sub rule 5 of your CPC. Okay. If you are doing this CPC for the first time, I think in my personal opinion, do not spend too much of time to memorize the case law. The case law is merely guiding you the application of the section. Okay? It is not like the previously when we study LLB. Okay, for example, you are from University of London. Okay, you study, you write a lot of case law, then your marks will flourish, isn't it? It is not so in CLB, but you have to memorize the specific provision and apply it right, then you'll secure a pass. Okay. So where were we? All right. So can pass any sentence. So this is exact wording from your SCA. Okay. And what are some other important matters that the session court will have would be I mean the lower courts will have in general would be they can actually inquire into complaints. This is your private prosecution. If take for example, I just give you a rundown first. If let's say for example the police officer, okay, they have the right to refer a case to magistrate, they have two choices. If they want to charge the accused to the court, they'll refer the case to public prosecution, attorney general chamber. If they do not intend to charge a person, they can refer the case to magistrate. Then the magistrate will over the role of PP and inquire into the matters with the presence of the complainants and also the respondent. Okay, so this is the private prosecution, but in practice, it is very rare, very rare. Okay, and other than that, the magistrate, usually this is the job of magistrate, can issue warrant of arrest or warrant of search. Okay, usually they are together lah, and also summons. Okay, and of course, the magistrate can adjourn the matters, remand, give bail, or even transfer the case to high court in the case of death penalty one. And session court can inquiries that is your inquest proceeding, and they can have power to try or to decide any matters if any written law authorize them to do so. Okay, this is the tricky part. That's why it's a lifelong learning, because there's no possibility for you to know every single statute in Malaysia alone. Okay. Okay. So next we move to High Court. So High Court has got its original criminal jurisdiction and appellate jurisdiction. That means it can act for the for hearing the appeal from lower court. And one more thing, very special power, it has the power to do revision. Okay, revision means semak. Okay, we talk about first thing first lah. Original criminal jurisdiction. Section 22 sub rule 1 of your Court of Judicature Act. This CJA only for your High Court. Okay, High Court and above. Okay. It said that High Court can try all offences under Penal Code and any written law. So everything. But usually it is reserved for death penalty. Okay, death penalty. Somehow or rather in Malaysia, it looks like it is a standard practice. The PP will transfer the so-called high-profile case, especially involving some politician, to High Court to try the matter as their court of first instance, due to justice must be seen to have been served also lah. That means to say, the accused, the famous politician will have the chance to appeal up to federal court. If the federal court had decided so, that means there's no miscarriage of justice here. Okay, that is the sole reason, I believe. Right. Section 22 Subrule 2 CJA said that High Court can pass any sentence allowed by law. That means inclusive of death penalty. They can punish a person 30 years into the prison. They can punish a person to death gallows also can. Okay, but still you must remember the maximum whipping is only 24. Okay, per case. And it has got appellate jurisdiction that is under your section 26 of your CJA to hear appeal coming from magistrate court or session court. Okay, so this is what it meant. If you have time, I strongly urge that you go through this section 22 CJA thoroughly. Okay, so this is section 26 on okay, appellate jurisdiction. Okay. And okay, we talk about revision. Revision, this is a very special power only granted to High Court to do semakan over some issue, okay, that is usually not appellable. The accused or the person that suffer injustice. Take for example, if you're not happy with the decision of an inquest, I use the case of Teo Bangkok here. For example, the family member is not happy with the decision of the inquest because the proceeding, if I'm not mistaken, the decision or the final verdict is so-called misadventure, or unknown, the cause is like open-ended. So they can actually file a motion usul semakan to High Court to seek for the High Court's decision to prevent this miscarriage of justice. Okay, and take for example, if you plead guilty also, you plead guilty in lower court, and subsequently you are so regretted and you think that you are getting some inducement to plead guilty, and then you miss the appeal period. Okay, we need to appeal within a time frame of period, isn't it? You miss that one. So after you went to the jail, for example, 6 months, suddenly you call up your family and say that you are feeling so regret to plead guilty, and you feel that there's something wrong in the lower court, the process is wrong, and then the guilty plea is not safe. This is one example. You can actually file semakan to the High Court. This is how it works. Okay, and the proviso that enable this High Court to do revision is actually the substantive law, the real power coming from your section 31, 35 to 37 CJA, and how you do it, the procedural requirement is under your section 3232 to 327. Okay, the procedure, for example, you file USO plus affidavit. So how this affidavit can be sworn by the person or the relative, something rather, is governed in your CPC. Okay, and most of the time, if you are answering any question, you need to write the section of your CPC. Okay. Apart from that, High Court and above, High Court and above, that means to say High Court CA, FC lah, okay? They all have so-called inherent jurisdiction. This is a common law principle. That means the power that given to the court to do something, but it is not a written law. It is not written inside any statute. It is not even written in your CJA, CPC. Anywhere it's not written. But somehow or rather, it gives the power to the judge to prevent abuse process of the court, ensure the fair trial, okay, and also filling the legal gap here. Very important, because you must look at this. No doubt civil court also have inherent jurisdiction, but criminal court, the inherent jurisdiction is far more important than civil court because you are talking about the liberty of a person. You're talking about the life of a person. So that's why technical, so-called procedural fairness is one very, very important element in criminal law, as in compared to the civil procedure, because person could be convicted based on the surface evidence. So usually the defense, us lah, I mean, we do litigation matter, isn't it? We have to look at every single technical loophole, see whether the procedural fairness is there or not. Okay, so this is to prevent any innocent person to lose their life or their liberty in the prison. Okay, very important. So High Court has its inherent jurisdiction. Okay, so Court of Appeal, quite simple now, I think. Okay, Court of Appeal only does appeal. It hears directly from High Court. Okay, so this is provided under Article 121 Federal Constitution and also Section 50 CJA. I know it's down, but I don't think you have any choice except for full memorization of what is it. Okay, so usually there are 1, 2, 3 conditions. Okay, we will discuss in detail in our appeal chapter. Okay, so you must remember if the case started from High Court, so the Court of Appeal is the second court. Okay, and the matter will subsequently end in federal court. Okay, if the case start at High Court, if the case start from session court, and then if it goes to High Court, and it will end in Court of Appeal. So thus, if a case start in Magistrate Court, it will goes to High Court and then it will ends in Court of Appeal. Okay, so at this moment of time, do not confuse yourself with regards to the differences of which party need to file a notice of appeal when the case goes through from lower court, I mean from magistrate court to Court of Appeal, okay? Or do not confuse yourself with anything to do with the question of fact or question of law. Do not study it at this moment. Study it during appeal chapter, okay? Section 60 of your CJA provides the power of Court of Appeal. Okay, it can actually confirm, reverse, or vary. These 3 words must remember. Not just 3 words, sorry, plus a retrial. Confirm, reverse, vary the decision, or order a retrial. So these are the main powers of Court of Appeal when they make decision. Okay, they can either uh, feel that, for example, they feel that the penalty is very light, they can increase the penalty. If they think that the High Court made a mistake, terkhilaf dalam undang-undang, for example, terkhilaf dalam fakta, they can quash the decision and um, uh, quit the accused. Okay, they can even order a retrial. That means to say you hear it again lah. Okay, if there is something really grave had gone wrong. Okay, very important. Somehow or other, you must remember that if it is involving criminal appeal, no cost shall be imposed on both parties. Okay, no cost. It means to say appeal in criminal process is free of court fee. No need to pay. Okay. So federal court, for example, the jurisdiction is still coming from your Article 121, Sub-Rule 1, and also your Article 128 Federal Constitution, whereby the federal court can determine appeals from the decision of Court of Appeal and High Court. Okay, that means to say it only has appellate jurisdiction in criminal matters. Okay, so again, you need to use your section 86 and 87. So federal court, very simple, not to say very simple, they are all law lords, isn't it? So they are very expert in law. So they only hear matters coming from High Court as the court of first instance. Okay, okay, only High Court, Court of Appeal, Federal Court. So this is the proper procedure. Okay, somehow rules of Federal Court 1995, the R137, provides that even if a case comes from lower court, if there is miscarriage of justice, you can invoke this inherent jurisdiction of Federal Court by pursuant to your Rule 137 to overturn the case which supposed to end at Court of Appeal. But bear in mind, this Rule 137, I think only invoked in Tan Sri Eric Chia case, the Perwaja Steel case. Okay, other than that, the court in the rarest circumstance will invoke this. Otherwise, it will open a lot of floodgates to case that is supposed to end in the Court of Appeal to bypass it. By right, you should have two tiers of appeal, Okay, lower court, high court, Court of Appeal, habis. But if you open up and you use this inherent jurisdiction, Rule 137, very often, then all the case that is supposed to end in Court of Appeal, they have another chance to go to Federal Court. So it's not easy. Okay. And the Federal Court also can determine some constitutional question. Should it refer by High Court judge? But usually these sort of circumstances, the High Court judge will menggantungkan like stay of proceeding. They hold the trial first, they refer the constitutional question to Federal Court. The Federal Court make a decision from there, then the High Court judge will try the matter. Okay, this is how it works. Okay, apart from that, the Federal Court judge, as you know, Malaysia practice democracy, isn't it? So we have parliament, we have your executive powers, usually played by ministers or authorities, okay? And then we have judiciary system. These three, by right, should enjoy separation of power. So in the matter that is relating to constitution, okay, so Article 121 Sub-Rule 2, okay, provides that Federal Court has original or consultative jurisdiction specified in Article 128 and Article 130. Okay, to advise, not advise me, not advise you and my other colleagues here. Okay, but this is to advise Yang di Pertuan Agong whenever there's a constitutional crisis happen in Malaysia. Okay, if you are interested with this matter, you can actually Google emergency state MCO, and then you can Google advisory jurisdiction of federal court. Okay, somehow or rather, there is some debate over the role of the Chief Justice of Malaysia to advise Yang di-Pertuan Agong whether the emergency should be declared lawfully or not lawfully in regards to this matter. Okay, and uh, any other court, we have local jurisdiction. Your section 121 of your CPC, okay, said that every offense shall ordinarily be inquired into and tried by a court within a local limits of whose jurisdiction it was committed. Okay. Unlike your civil proceeding, we have forum of non-convenience in favor of your defendant. So the jurisdiction of the court usually will be the residence or the business address of the defendant. That is civil proceeding, but not applicable to local jurisdiction, the court, criminal court per se. Okay, criminal court, usually the location is decided where the offense is committed. Take, for example, I will need to use my wife as as an example. I killed my wife in Batu Pahat. Take, for example. So the high court that have local jurisdiction will be more, okay, because Batu Pahat more very near rather than Johor Bahru. So this is what it means. It doesn't mean that I'm coming from Penang, so by right it should follow my address back in Penang, not like that. Okay, so I hope you understand. And Section 2 CPC defines what does it mean with local limits of jurisdiction. Pay attention on your section 2 CPC. Surprisingly, you can get a lot of answer from section 2. That is to say, what is seizable, non-seizable offense, what is bailable offense, you can get it from there. What is warrant, what is summon, you can get it from section 2. And the local jurisdiction of subordinate court is, of course, governed by your SCA. That one I already told you. SCA is exclusively provide the authorities, the power for magistrate court and session court. Okay, you can have a look at section 76 pertaining to magistrate court and also section 59 pertaining to your session court. Okay, so local jurisdiction, one more thing, for high court per se, it is section 3 of CJA. Okay. I think this is quite simple. And so this is the local jurisdiction chapters that you need to know. Okay. Whenever there's a question that asks you whether the location of the court itself is suitable or not, then you must make reference to your section 121 to 127B. But usually 121, 122, 123, 124, and 125, 126. Okay? Usually this is how it goes. Like I take, for example, I killed my wife in Batu Pahat, but subsequently I want to hide the body of my wife. Okay, I bring my wife to Malacca and throw the parts of the body in Malacca. Okay, Sungai Malacca. I throw it there. And then to hide further, I run back to Kuala Lumpur. And unfortunately, in Kuala Lumpur, I got caught. Okay, and there are some evidences inside the condominium that I stay in Kuala Lumpur. So how this thing goes? So whether I should be tried in Muar, Malacca, or Kuala Lumpur. Okay. The thing is, It all provides here, okay, from your chapter 14 of your CPC. So wherever is it, usually I will be tried in where, Kuala Lumpur, because the place where I caught, where they will actually see how to facilitate Chi to be charged in the court, how to facilitate this the chain of evidence, So usually it is the place where the accused is being caught. And it is of course not wrong, not wrong if my case went to High Court Muar or High Court Malacca. It's not wrong also because it is legal under your chapter 14 of your CPC. Okay, because one of it, okay, then you can try already. Okay, understand? Okay. Hmm. Okay. Okay, we look at one question here. Very simple. Okay. Uh, Mr. Anas, a DPP, okay, who recently joined prosecutorial services in AG Chambers, Putrajaya, wishes to know from you the law regulating the prosecution of an accused in a criminal case regarding number one, open court proceedings, and number two, in-camera proceedings. Okay, advise Mr. Anas on the relevant laws. 10 marks. Okay, so this I plan to cover in such a way so you remember this is important. Okay, normally the court is open to public. It is called open court proceeding, provided that your attire is all right. That means to say you are not wearing something that is menjolok mata, too sexy, short pants, undecent looking, all that. Okay, indecent looking, sorry. So it is aimed for public. Anyone can access to the hearing, can hear what the judge say, and can hear how this trial is being conducted. This is pursuant to your section 7 of CPC. Okay, please memorize this, open court proceeding. And in answering this question, you can copy down whatever that is provided inside your section 7 CPC. Okay, and you make further reference to section 101 of your SCA that is provided for all the criminal lower courts, magistrate court or session court are open to public. Okay, this is your general provision. But somehow or other, if the case is concerning to public safety, interest of justice. Take, for example, it is involving some official secret act, okay, Akta Rahsia. It concern to the military issue. Kementerian Pertahanan case, there's some submarine that is being stolen or whatsoever. This is highly classified matters. Okay, then the case could be held in camera. That means public is blocked, only certain officer, court officer, and of course, including the judge, are allowed to attend the trial. The public, the media, some even related individual, if they are not the witness, unfortunately, they cannot enter the courtroom. So this is called in-camera proceeding. Okay, so in the event of court for children, it is also in camera because usually in a criminal matters for a minor, you don't even see the name one, You see PP against A. You see PP against K. The A, B, C, D until K, whatever abbreviation they want to use, is to protect the child. Okay, you get me? So the proceeding itself is also private and confidential. Okay, and this is under your section 2, subrule 3 of Child Act 2001. All this you need to memorize. And this is section 27 of your Official Secret Act 1972. Okay, regarding to any public security problems of Malaysia, you cannot publish it. You cannot, after that you make a tweet. Oh, today the trial is about the somebody stealing a nuclear weapon from Malaysia to somewhere. You cannot say like that. Okay, you will be caught to jail. Okay, and in most of the time, the prosecution has to apply for in-camera proceedings. Okay, if the judge is satisfied it is in the interest of justice, usually it will be allowed. Otherwise, it will be all apa nama public access lah. That means open court proceeding. Okay. So now we look at one more question. Okay. So on 26 May 2023, OKT, orang kena tuduh, was arrested by the police, and the next day he was charged for self-administration of drug under Section 15 Subrule 1 Subrule A DDA 1952, which is punishable under Section 39C Subrule 1 of the same act. So Section 39C Subrule 1 provide that if a person is found guilty of an offence under Section 15 Subrule 1 Subrule A, he shall be punished with the punishment for a term which shall not be less than 5 years, but not exceed 7 years. So this, please highlight here, 5 to 7 years. Okay, and he shall be punished with whipping of not more than 3 strokes. Okay, the prosecution was conducted by Inspector P.O. After the charge was read and explained to OKT, he pleaded guilty to the charge and was convicted and sentenced to 5-year imprisonment and 1 stroke of ratan. OKT was not represented. Okay, we will look at question B straight away. Which court will have the jurisdiction to hear the case? Okay, so if you rely on this trial jurisdiction pursuant your section 85 of your SCA, okay, you'll know that actually magistrate court will have jurisdiction to hear this matter. No problem of hearing, okay, because the fine and imprisonment not exceeding 10 years. Here, the shall what? Shall be punished with imprisonment for term not less than 5 years, but not exceed 7 years. So we have no issue. Hearing can hear. Okay. But what about sentencing? Okay, sentencing part is one thing. Okay. Remember, I said to you, the general proviso of the sentencing jurisdiction for magistrate court is provided under your section 87 Subrule 1 of your SCA, which is 5 years max, max. Okay, but now OKT was sentenced to 5 years. Okay, you get me? So the place magistrate court is the right forum. Okay, but your question should not end here, even though the question itself does not mention whether it is in Kuala Lumpur, Batu Pahat, Mall, etc., you must also mention local jurisdiction, because there's no such thing the case can be tried at magistrate court. Of course, you need to know where, isn't it? So you have to submit something lah. You submit to the place where OKT was arrested using your section 121 CPC, okay, and also section 76 SCA. And then you jump to the conclusion, magistrate court is at the place of OKT arrested is the right forum, okay, to hear the case and also sentence the case, okay? As simple as that, okay. I think this topic is rather simple. Let me just off the recording first. Wait.